in the matter of Roberts and Severn Trent Water Limited and Severn Trent PLC and others.
Just before you start, Mr. Turner, can we thank Ofwat? Thank you very much for your paper. I personally don't have any questions. No, we don't have any questions, but we're nonetheless grateful for the input. Yes, somebody's put in a paper, have they?
No one's put in a paper, my lord. We have an additional authority. It was the other authority that you were canvassing with Mr. Hoskins yesterday.
What was that?
You said, are there any other authorities on this question?
Oh, not AstraZeneca.
Not AstraZeneca. There is one, and I'm just going to address it very briefly. For that purpose, we notified my friends yesterday, and we handed copies, paper copies to the court, and it's been emailed to your clerk.
Okay.
It's called Rambus.
Now, we realise that the court thinking about a case is to be discouraged, certainly by advocates. But I want to ask you a question, Mr. Turner, and I would like your considered answer to it. So the material part of section 18.8 might be said, for the purposes of this case, to be where any act constitutes a contravention of a condition of a water company's appointment or a license. The only remedies for that contravention shall be those that are available in respect of that act, otherwise than by virtue of its constituting such a contravention. Stripping out the words which make the other words, which just make it very difficult to understand. So the words that need to be construed on one analysis might be said to be remedies that are available by virtue of its constituting such a contravention.
Or otherwise than by virtue.
No.
Oh, by virtue, yes, I see.
Because it is only those remedies that are barred.
Yes, I see.
You're taking the negatives and the otherwises out.
Yes.
Make it difficult to understand. Okay. And Manchester Ship Canal seems to have decided that remedies that are available by virtue of their constituting such a contravention are only those in respect of which the contravention is an essential ingredient of the claim. And that was in the context of nuisance claims, which are far away, really, from Chapter 2, infringements for abuse of dominant position. So the question is, maybe, I mean, this is presented with great hesitation, can it really be said that the penalties to be imposed under Chapter 2 are remedies that are available by virtue of its constituting such a contravention? And the answer may depend on whether the abuse of a dominant position alleged is a dominant position provided for, because the dominant position alleged that you're abusing is one provided for by statute, where the regime is to protect the public, and that regime is in the licensing and the conditions that are imposed. So one might ask how the water companies can really be said to be abusing their statutorily imposed dominant position unless they're failing to comply with the regime. Leaving the pleading aside, because we quite understand we may have to do a meticulous analysis of 400 pages of pleading, which we're very much looking forward to, Mr. Tanner. But is that not more the crux of the question that has to be answered? In other words, whether the water companies are abusing their statutorily imposed dominant position by failing to comply with the regime, whether that is the essential ingredient.
So, if I may, I'll give a direct and quick answer to that.
And rude answer, I imagine.
No, it never is. The competition rules apply to abuse of dominant position. The fact
Hang on,
that
I
these...
just want to get, let me have my full concentration on your quick answer, Mr. Turner. Yeah.
Competition rules apply to abuses of a dominant position. The fact that these undertakings have dominant positions underpinned by statute, their statutory monopolies, explains how it is that they enjoy the dominant position. It is not the case that this regime is intended to exclude, on that account, the operation of competition law. This can be seen from the express statements in the statute, some of which I have taken the court to,
Yes,
which show that competition law is to be operated in parallel, and indeed that if Ofwat were to consider it to be more appropriate to use the competition powers in relation to overlapping matters, then it is able to do that. That relates both to the enforcement powers and in relation to penalties. Finally...
Isn't that a sideshow? I mean, of course, you're right. Ofwat can use its competition powers and can use the law of competition and may wish to do so in particular cases. But this is not a question about that. It's a question about the construction of Section 18.8 and its proper meaning.
It is. My submission is that, and now I'm going to just develop it in these short number of reply points, I was going to say supply points, reply points, is that what is meant by virtue of it constituting a contravention means that the cause of action, whether under competition law or nuisance or any other independent actionable right, is not reliant on there being a contravention of the conditions of appointment. Applies in that way in relation to any independent breach of duty. And therefore, and I will develop this with my first point in reply, the key point for this court is to ask itself, drinking from the pure waters of the statutory provision, whether this is a claim that is reliant upon a contravention of the conditions of appointment. Mr. Gregory just adds, by way of supplement, these monopolies are not created by the statutory regime. These are, as it were, natural monopolies, and the statute has come in to impose a layer of regulation on top of a situation of natural monopoly. I'm not sure. I'm not going to. If I may, then, I'm going to deal with these points in reply. First point, I would like to go straight to the issue on which Mr. Hoskins spent the bulk of his submissions yesterday. That is the argument that whether statements to a regulator count as misleading for the purposes of the competition claim needs to be considered in concrete. His starting point was that paragraph in the AstraZeneca case. And then he said, in the present case, inspection specifically of our claim form shows the court that the pleaded case is substantially dependent on establishing contraventions of the respondent's duties under the conditions of appointment. And he took you to certain paragraphs. This argument is wrong for these reasons. If I may, please, if we could begin by just turning up again the relevant paragraph in AstraZeneca, paragraph 357 in the authorities bundle, page 698, and over page 699.
You can't give us the reasons before we go to the authority, can you?
I'm sorry, give us the...
It was portentous when you said, this is wrong for these reasons.
Oh, I see.
I'd like to know what those reasons are.
Yes.
I'm
Well,
on the edge of my seat.
The reasons are
Yes.
that, in principle, as I will now briefly show you, I'm tracking
Yes.
what was said to the court. In principle, to establish this sort of competition claim, it is not dependent on showing contravention. The question of what is misleading, which was canvassed with the court in the opening submissions, depends on showing something that is relevantly misleading because it is liable to lead the authority into the error that means that the companies can charge the excessive prices. That was...
So just say that again. It's not dependent on showing breach of the condition.
No, yes.
What is it dependent on?
It's dependent on showing that there has been an act or omission, in the misleading statement to the regulator,
Yeah.
which causes the regulator to act in a way which removes regulatory obstacles or otherwise harms competition or enables, in this case, the companies to exploit market power to the detriment of consumers. And so what I will show you by returning to that quickly is that the gist of the cause of action under competition law does not touch the sides of a contravention of the conditions of appointment. It's not concerned with that in principle. By the way, that is something which the other authority, which we'll come to, also shows you. Then, what I propose to do is to respond to the point that when you look at our claim form, you see that it is relying on contraventions of the conditions of appointment. And I will seek to say that that is entirely wrong. And I will show you why.
Okay, thank
So
you.
if I may begin with
Yes.
paragraph 357, bottom of page 698. We've now looked at this 3 times, so I'm not going to read it out again.
357.
The key part is at the top of page 699. And for what is meant by assessing in concreto, the key sentence is the one that begins, in particular, it's necessary to examine. And it tells you that what is important is that one is examining the context in which the statement's been made, and you're asking whether it is liable to lead the public authorities, as I say, here wrongly to create obstacles to competition, and in our case, we say, to exploit market power in a different way. That is the gist of the competition law theory. To answer the question whether it's liable to lead the authority into error in this way, one needs to establish what the information supplied by the dominant firm is. First, what is it? And then see why supplying it is claimed to be liable to lead the authority into error. And that will be a feature of every abuse case which is based on this approach, this case theory.
So you need to establish, say it again.
You need to establish what is the information which is being supplied by the dominant firm to the regulator, the relevant act. And then you ask yourself, why is supplying that said to be liable to result in these adverse competition effects? How does this happen? If a dominant firm supplies information in a way that then produces those consequences, that is the abuse. That's the underlying theory. In our case, this involves establishing as a fact, what information on spills of sewage is required to be given as part of the price control regime, which may be more or less detailed in what is specified as needed, and then you compare it against what actually has been given. Here we say very substantial underreporting. And then, to follow the case theory, you ask whether this was relevantly misleading in the way that I've explained for a claim in abuse. It affects the price control, enables the companies to exploit consumers. Now please, if we go back to section 18.8 itself, although I now apprehend that all members of the court know this by heart.
Well, we sort of do, but it's really important to have your nose in it.
Yes. So, section 18.8 just have the words in front of you, page 13 of Authorities Bundle 1. And now I'm essentially rather playing back my Lord's own statement at the beginning of this hearing, that the exclusion does not apply to, in the last words, remedies that are available in respect of an act or omission otherwise than by virtue of it, the act or omission constituting a contravention. So I agree with the way your Lordship put the point to me. The exclusion bites if there is reliance on constitution of a contravention. Here, the remedy in damages is sought on the basis of the difference between the factually inaccurate information that was provided by the sewerage companies about the amount of the sewage spills and the information that should have been provided in order not to distort the price control and result in excessive charges. This case, before we just look at the paragraphs, does not rely on the underreporting being a contravention of the conditions of appointment. It does not rely on the act of providing misleading information by virtue of its constituting a contravention. And what Mr. Hoskins argued yesterday about this claim form being reliant on showing contravention is not correct. The detail on what is expected by Ofwat to be reported by the sewerage companies isn't to be found in the relevant condition of appointment itself, condition B, paragraph 9. There's no need for Professor Roberts to establish that there's been any breach of condition B, paragraph 9. She does not rely on that contravention at all. The need is to look at the various regulatory materials that spell out the detail of what Ofwat takes into account when it sets the price control. And those explain the system of rewards and penalties for pollution incidents that are reported. And it includes, among other things, what are called performance commitment targets and various related documents with technical names. And you look at those operational documents without needing to address the legal issue of contravention of condition B, and nor is that alleged in the claim form. If I may now then show you that by returning to the claim form, supplemental bundle 3, and go in it to page 130, paragraphs 8 and 9, that and the following page.
But, I mean, just before you go there, I mean, that is an allegation about subverting the regime, is it not?
It's not an allegation about subverting the regime, relying on the contravention as such. It is saying that matters which also involve a contravention are not relied on for that purpose as part of the claim. They are relied upon not because they are subverting the regime, but because they are liable to lead the regulator into error and produce these adverse consequences.
Can I put it this way? The claim is framed by reference to the regime, put it that way. You look at the regime to determine whether the information provided was the information required to be provided. If you didn't have the regime, this claim would not make sense, would it not?
Well, I think 2 points in response to that. The first is, it's not a case of saying if there wasn't a regime, there wouldn't be any reporting, as it were, going back in time. The fact is there is a regime, and it's not a question of looking at some underlying cause for the problem that has arisen. The second is that we are referring to the failure to provide the detailed information under the regime and we are appealing to the fact that that has created the opportunity for these companies to exploit their market power as the gist of the claim.
I understand the competition law
Yes.
claim, and the fact that you say I can plead that without pleading breach.
Yeah.
I can understand it intellectually, but let's stand back. Whatever else happened in Manchester Ship Canal, I think they adopted a purposive approach to interpreting Section 18 sub 8. They didn't apply a literal approach. It's actually quite remarkable that there is nowhere in that judgment that they said, say, well, what does by virtue of mean? They don't spend time on that. They're applying a purposive approach. So that is clearly one thing that case is authority for. So where does that take us? I think one place it does take us is that you can't take a very narrow view, I would suggest, in looking at by virtue of and doing what you've just done, just to put the point back to you, which is to say, aha, I've managed to plead a claim that doesn't include reference to breaching a condition of appointment. I completely understand that, but I'm not sure that's a complete answer, because we've got to take I think the Supreme Court is telling us to take a purposive approach to interpreting the provision. Your claim is at least framed by reference to the regime and would not make sense without it. In a sense, the regime is a but-for, you could say,
yes,
but-for element. Why isn't that enough? One of the references in Manchester Ship Canal at 124 says, does the remedy depend on the breach of statutory duty? In that case, the duty to, say, build a sewer. Does your claim depend on a breach of the conditions of appointment, even though, like Mr. Marchett is claiming nuisance, it is not pleaded explicitly by reference to the duty to report under the regime? So that,
yes,
for me, is the core of the question.
Yes.
I'm not saying the answer is
no. If I may, let me deal with that and then return to what I was saying, because I'm grateful. The first observation, I would not agree with respect that it is only a purposive interpretation that has been adopted. In the relevant paragraphs of Manchester Ship Canal, from my memory, it's paragraph 57 that was referred to, and probably paragraph
58, I think. 57 and 58.
Yes, and 133, I think, the conclusion. They do record what the statutory language is in section 18A by virtue of, and they say this means they are having direct regard to that. I absolutely agree that they're also looking at the matter purposively, and there, a central concern of theirs, expressed in a number of ways, is that if there's a statutory clause which may take away private law rights, it has to be construed very narrowly. Either it has to be express words or by necessary implication, or else it won't do that. The purposive nature of the analysis was the concentration on the importance, the critical importance, of preserving private law rights. My Lord Justice Zacaroli referred, for example, yesterday to paragraph 118, one of the paragraphs in which it was said, look, if this does remove a private law right, which would otherwise be a basis for a private party to gain compensation for a breach of their legal entitlements, then it's material to know whether in its place compensation is going to be available under the scheme. All of the purposive analysis of their lordships in my submission was directed to this point, that if you have a private law cause of action available, then section 18.8 should not be interpreted so as to remove it. Then we come to my ladyship's concern, which is that how does that apply in the case of a detailed regulatory scheme such as this, where of course it is true that the claim is based on the operation of the regime as its essential context. We know that where sector-specific regulation is at play from the point of view of competition law, it can apply. Does it apply in reverse, that where you have sector-specific regulation, section 18.8 means that competition law, as it were, is somehow excluded? And we say no, because the price regime is the basis upon which you can see the way in which the undertakings mislead the regulator and thereby achieve distortion of competition. The fact that, as their lordships say in Manchester Ship Canal, the operation of the regime might itself be the underlying cause of the problem, they repeat in numerous paragraphs, does not matter. The fact they say, I think paragraph 89 or thereabouts, that the statutory provisions might even provide, refer to precisely the same conduct as is the case, that is the basis of the common law complaint, neither does that matter. And they return at the end to that final conclusion that the essential ingredient must be contravention that is relied on. And we say that the proper interpretation, therefore, is that you are looking to see whether this is, as it were, a form of follow-on or piggybacking claim from a breach of contravention of the conditions of appointment. And what I would hope to do in the next couple of minutes is just to look at the claim form to try to illustrate why this is not the case.
That's very helpful, thank you, and particularly your reference to essentially the complaint being that the companies have used the regime to achieve, to abuse a dominant position. I understand that point. Can I put one further follow-on question, which is that you emphasised rightly that the Supreme Court was concerned about the removal of private law rights, yes, and said should not be done except very clearly, essentially. What do you say to this, that the private law right in this case is not like the nuisance in Manchester Ship Canal, where there was hundreds of years of case law establishing a common law duty. Here, yes, I know there's a competition law duty, but it's being applied very much in relation to the regime. Put it another way, it comes back to my earlier point.
Yes, it does.
The but-for point,
yeah.
The regime, this particular right to claim the competition law remedy would not exist. This particular claim would not exist but for the regime. So it's not quite the same as whether Section 18.8 removes an existing private law right. Do you see what I'm saying?
I do. So this, I agree, comes back to the point that your ladyship foreshadowed yesterday, that in Manchester Ship Canal you have an existing common law right, which is essentially independent of the statutory regime, nuisance, and the damage resulting from nuisance. In Marchett, you had an exclusion because the only breach, the only contraventional breach that was relied on was something that arises only under the Water Industry Act.
Yes.
And so they said, well, that can't run. And your lordship raised yesterday and puts again the point that here we have something which might be termed a form of intermediate position, because competition law, as you've seen, has an area which is which is devoted to cases where a dominant firm can mislead a regulator, which must be within the context of a regulatory regime. That is how you mislead the regulator inherently. And the question is, for this new type of situation, how does the judgment of the Supreme Court, how does Section 18.8 apply to it? And my answer is that the ruling in the Supreme Court and the direct wording of Section 18.8 give us the answer, because one is still asking whether contravention of the conditions of appointment, that breach, the Water Industry Act contravention, is the gist of the cause of action. And what I hope to illuminate in the course of the remainder of my reply is why that is not the case. Why, in short, what is relied on are certain factual matters, albeit with a detailed context, which result in the dominant firms gaining the ability to exploit their market power. And to show that this arises essentially as a factual matter without needing to touch the question of contravention, although I accept, and it is obviously right, that all of this applies within the framework of a price control regime, as any case of misleading the regulator, almost any case, must. So if I may, then to follow this point through, if we go to the claim form. If we go to the claim form, yeah. It's at supplemental 3, and in it, take the first of the paragraphs, I think it was, that Mr. Hoskins referred to, paragraphs 8 and 9, beginning on paragraph 130. Now, this is part of his argument that there is reliance on contravention. I just want to go back and look at this with fresh eyeglasses. 8 says, as part of the system of regulatory incentives adopted by Ofwat for the purpose of its periodic review 14 and 19, sewerage companies have specific performance commitment targets relating to the number of pollution incidents on their networks. And it explains that if you outperform them, you do better, and equally that if you breach them, the reverse. 9, in order for these controls and incentives to operate effectively, the sewerage companies must provide Ofwat with accurate and complete information. So it explains the system. So here we are referring exactly to the framework in which all this occurs. We're not here talking about contravention. And if I may just show you a short chain, try to make my point good. If you go forward to paragraph 126 on page 159. This again is now giving more detail on the point. Consistent with standard practice in each of these 2 price reviews, Ofwat determines 1, these targets, performance commitments, and 2, associated financial incentives, outcome delivery incentives. So it's explaining how that works. If you go forward to paragraph 136, page 164, I'm going to read this, but cast an eye over it, you see that it shows the detail of the particular performance commitments for Severn Trent. This is a Severn Trent claim form for the claim period. That is what needed to be reported, so it's set out in detail. This is what must be done. Now if we go forward to page 168, paragraphs 145 to 147, point this out. This begins in accordance with, it's another regulatory condition, condition F, that is F1. Ofwat publishes RAGs, Regulatory Accounting Guidelines, setting out detailed requirements in relation to reporting. 146, among other things, the RAGs have required the defendant to produce annual performance reports, included tables with information, including in relation to these performance commitments. So you see the detail of how it is all set out, what they need to report. And 147 this is why I take to it, pursuant to its licence conditions and the RAGs, the defendant was required to provide, and did in fact provide, in its APRs, these statements. This is what it did. And that is the information referred to collectively as the Ofwat PI, or pollution incident information. So here, this is referring to, it is true, another licence condition in accordance with condition F, and it is commenting also at the beginning of paragraph 147, pursuant to its licence conditions and the RAGs, the defendant was required to provide and did in fact provide. But the fact that that provides the context, pursuant to its licence conditions and the RAGs, that is part of the background, that's part of the explanatory part of this document. You could remove those words without difficulty, because the relevant question is what was needed to be provided for the purpose of the claim. And if I go forward now to the abuse section itself, which starts at paragraph 164 on page 176, under the heading Misleading Abuse, Mr. Hoskins again asked you to look at paragraph 164 in this connection. If you look at this again, you'll see that the claim is put in terms of the provision of information that's relevant to Ofwat's assessment of performance, and then explains, calling on the previous information, how this was done. But it is not a claim of contravention, a breach of condition B, paragraph 9, at all.
Well, I appreciate that. I'm still struggling a bit that it necessarily involves a breach of that condition. I know you say that. I mean, I think that's the essential difference. You say it doesn't matter.
Well, what I say is that, assuming that to be the case, it is coextensive, it is in parallel, it is separate. And therefore, you come to the arguments that I dealt with very briefly in my comments on the respondent's notice in the opening submissions, which is that just because they were to say, well, if there wasn't a regime at all, none of this there wouldn't be an abuse, or if they hadn't broken their regulatory obligations, then there wouldn't be a problem either. Those points are actually addressed by Manchester Ship Canal. So then he refers to 167 as well on page 177, which explains why this PI information provided was misleading, systematically understating the number of pollution incidents on the network that are relevant. And in short, without conscious this is a reply, and I said I would keep it short, there are actually no references at all in this to condition B. And if condition B, paragraph 9, didn't exist, it posed this point, if there was simply an expectation that the companies would self-report based on all of the detailed specification that I've shown you now, just an expectation, that was the arrangement, the matters needing to be established under this claim form to make out the abuse claim, those would be exactly the same. There's no need to determine whether providing the misleading information is a contravention of the duties under condition B. And in summary, if you go through this, there are a small number of references in the claim form to the licence obligations, such as the ones that I've showed you there in paragraphs 145, 147, and those can be very easily stripped out without affecting the pleaded case at all. And if I may therefore return to the test that was posed by the Master of the Rolls yesterday, and echoed again in the remarks at the beginning of this hearing, if there is a freestanding private cause of action, which there is, that relies on acts and omissions, but does not rely on them by virtue of their constituting a contravention, then the contravention is not an essential ingredient. So that That is my response to the bulk of my friend's submissions. Second point. Yesterday, my Lord Justice Zacaroli canvassed with Mr. Hoskins the points that I had made in relation to paragraph 43 of the tribunal judgment. That was the first of the paragraphs, of two paragraphs, in which the tribunal said, we find that there's an exclusion because section 18.8 comes in at the stage of causation of loss and damage. If I may invite the tribunal to turn that up again, paragraph 43 of the judgment, core bundle, page 107. This is where we say, you recall, the tribunal, in its reasoning, falls into error because it comes to conflate or confuse the operation of the price control regime.
Which paragraph?
43. Foot of the page 107 of the bundle. It here appears to conflate operation of the price control regime and an allegation of contravention of a condition of appointment. And my point was put to Mr. Hoskins that what the tribunal says in the sentence at the top of page 108 about why it believes the damages claim is excluded in this case at the causation stage is correct. That is correct, put another way, it just doesn't engage section 18.8. Just to read that sentence, put another way, the tribunal said, the failure to supply accurate information for the statutory regime of price control under the Water Industry Act is an essential ingredient of the claim for breach of statutory duty. So here, this point that we have just been canvassing about whether contravention comes in or you're just talking about the regime is crystallised. And Mr. Hoskins responded to the question by referring back to the previous sentence at the bottom of page 107, because that includes the phrase, and the PDs, potential defendants, contravene the conditions imposed on them as part of that sentence. And his response was that the put another way sentence needs to be read as a piece with that earlier previous sentence. Now, leaving aside the point that the words put another way indicate that it's meant to be an alternative way of framing what the tribunal's point is, the observation that I made in opening and made again this morning is that the tribunal's reference to the defendants contravening the conditions imposed on them there is entirely superfluous to the rest of the content of paragraph 43, as well as being incorrect for the reasons that we've gone through this morning. The very first sentence of paragraph 43 shows you the tribunal's, the nub of their concern. In our view, the price control mechanism imposed by Ofwat, the price control mechanism, is therefore integral to the loss alleged by the class members. So it stubbed its toe on the point that it's the price control which is integral to the loss. And indeed, those words at the bottom, contravene the conditions imposed on them to supply Ofwat with accurate information, those can perfectly well be replaced by two short words, did not. The defendants did not supply Ofwat with accurate information without affecting the sense of paragraph 43 at all, and then consistently with the put another way sentence that follows. This is all to say that the sudden reference to contravention that comes in there is misplaced. The third point is that the thought experiment that I articulated in opening was put by your ladyship to Mr. Hoskins, and that was that if Ofwat decided to proceed against these companies for abusively misleading behaviour, taking the same points that we are taking in the claim form. You've systematically unreported, you've led us into this error, it's caused you to be able to overcharge. And if it then came to a competition law decision, public decision, then Ofwat would specifically have chosen to avoid relying on the Water Industry Act contraventions. And it would be relying on its statutory power to do that, which we looked at in section 19(1)(b). And what I said was that if then Professor Roberts brought a follow-on claim for damages on behalf of the householders, it could hardly be said that she was relying on the contravention of the conditions of appointment as an essential ingredient of her claim, any more than Ofwat would be. Both the actions, the public action by Ofwat, the private action, those would look at the provisions of the regime to see what information was used and to assess whether what was supplied was relevantly misleading. Now, in response to your ladyship, Mr. Hoskins suggested the answer is that section 18(8) would be construed to prevent Ofwat taking action under competition law. You have the...
I may have got this wrong. I rather understood his response to be that section 19 maybe preserve the ability of Ofwat to bring the action, but by implication not others. But I may have misunderstood that. I haven't looked back to the transcript.
No, in the dark watches of the night, I did look at this transcript. If you, assuming the court has it, it's page. Well, I have it. I must actually have a full. I have page 162. Let me just turn that up and see if I've got that right. Yes, 162. Your ladyship asks, hang on, if section 18(8) is that broad, it would prevent Ofwat taking action under it. Mr. Hoskins, that is the point I'm making. He said, if we were here on the basis of a Competition Act decision having been adopted, and this was a follow-on damages claim, we might be debating the relationship between Ofwat having chosen to exercise Competition Act powers in section 18(8), and whether the fact that Ofwat has exercised its discretion, that must mean, to proceed under the Competition Act means that section 18(8) can't be applied.
Okay, I'm afraid I read from that we may have to have a clarification. I read from that an indication that Ofwat could take competition.
Oh, could?
Yes.
Can I help?
Yes.
What I was intending to convey was there would be a legal issue there, and it's not one we have to consider for the purposes of this appeal. We could have the debate that would arise about whether Section 18 sub 8 could apply to a Competition Act decision by Ofwat, but I didn't intend to express a view on what the answer to that legal issue would be.
That's very helpful. So the submission is you're getting into murky waters there because section 18(8) might mean that you can't Ofwat take action under your Competition Act powers. And my response to that is that with respect, that is an impossible submission and it is not an appropriate way to duck grappling with the thought experiment that I posed. And that is because the very confined scope of section 18(8), that exclusion, is pretty clear, and it's now been comprehensively explained in Manchester Ship Canal. It only concerns the exclusion of claims for a remedy in the limited circumstances that we know about. The notion that it would even arguably be given a scope far beyond that to prevent Ofwat from exercising powers is, in my submission, fanciful. And therefore, the thought experiment and the light it casts on the issue now before the court hold good.
Well, I think that's the point I was trying to get at.
Yes.
Which is where this is a question of statutory, ultimately, of statutory interpretation of section 18 sub 8.
Yes.
And if Ofwat if the next section, I think it is the next section, is it? Section 19?
Yes.
Contemplates Ofwat being able to take competition action, that potentially casts some light on the correct interpretation of the provision.
Of section 18.8?
Yes.
Would your ladyship?
Well, all I'm trying to say is, I
Yes.
mean, it's relevant to your thought experiment.
Yes.
Your thought experiment goes to, look, the legislation contemplates that at least Ofwat can choose to take
Oh, I see. Yes.
competition action.
Yes.
Now, presumably when this legislation was introduced, we didn't have the collective proceedings
No.
that we have now, but we would have had, so in practice, there wouldn't have been this sort of mass action possibility in the mind of the, notional mind of the legislature, but
Yeah.
there would have been, and there is contemplated in the legislation, the power for the regulator to take action under competition law. I mean, can I put the question another way? What other sorts of competition action might Section 19 contemplate?
Well, there have been, we've referred to it, and they're in the bundle, a series of cases in which action has been taken. There's a case called Albion Water
Yeah.
concerning margin squeeze and excessive pricing. Margin squeeze, I think, was the point that Ofwat took in its original decision, where there is a statutory regime, but it says we're going to proceed under our Competition Act power to address a question using that toolkit. So, and then you will see Ofwat's guidance, which is also referred to in the claim form. I'm not sure if we've got an extract in the authorities bundle, but it's certainly explicit in the claim form. That gives the examples of where Ofwat may choose, under that guidance written before the mass action regime, to use competition law. And the point here that I was seeking to make is that if the regulator just avoids dealing with the question of contravention consciously and says, I can find that they have broken competition law without using that contravention power at all, and Professor Roberts simply piggybacks on that with a follow-on claim, how could it possibly be said that a claim identical to this one was dependent upon a contravention of the Act? Yes. So that was the third point. The fourth, very briefly, is this other relevant authority. Because my Lord the Master of the Rolls asked Mr. Hoskins whether there were any other cases on this abuse of misleading authorities. Mr. Hoskins said there's probably one decision of the Commission, but it was not helpful. Transcript, page 134. Our claim form, in fact, directly refers to that other case, and it is helpful, in my submission, in this appeal, on one point. If you have our claim form, it's paragraph 163 on page 176. Short. In addition, in a different case, the Commission has stated it may be abusive for a dominant undertaking to charge prices higher than those it would have been able to charge if it hadn't deceived a regulatory body. The footnote takes you to this Rambus case. I don't know if the members of the court have that in hard copy.
I've got it.
Or electronically. I'm not going to take you through this in detail. I'm just going to show you a couple of paragraphs.
Which paragraphs?
The key one is 39, and I'm just going to show you the lead up to it. But paragraph 39 has the point that I want. Put shortly, this is a decision where the Commission accepts commitments to address competition concerns. And the decision here explains the Commission's reasons for suspecting an abuse of dominance. And in a nutshell, you had an industry-wide standard setting organisation along the lines of, the court may be familiar, ETSI and Senelec and so forth. This one's called JEDEC, and it was concerned to set an industry standard for a component for computers called chipsets, and it had a policy to require its members in the industry to declare, put their hands up if they've got any patents or proprietary technology that might read onto these standards, because then if they adopt these standards and the industry is locked into it, potentially these members can hold people to ransom by just relying on their patents. So if you go to page 8 in the document at 36 at the top of the page, sorry, 35 on the previous page refers to JEDEC's policy to exercise care when considering standards that might require the use of proprietary technology, and they wanted to know whether there were patent rights around. And at 36 they say, to give effect to this policy, all members were required, or at the very least expected, to disclose to JEDEC any and all issued or pending patents of which they were aware that were relevant to these standards. 37, the Commission provisionally concludes that JEDEC and its members relied on compliance with the patent policy in developing industry standards. Paragraph 38 said that the Commission had provisionally concluded that there was, that the policy and the underlying duty of good faith intended to provide members with an opportunity to develop open standards free from potential patent claims. And they explain what the policy was. But then they say this in 39, it should be noted, however, that while the Commission considered that Rambus, which had supplied, they hadn't told, they deceived JEDEC because they didn't tell them about the patent. While they may have breached JEDEC's patent policy, an actual breach of the precise rules of a standard setting body would not be a necessary requirement for a finding of abuse in this context. The finding of abuse would rather be conditioned by the conduct that has necessarily influenced the standard process in a context where suppression of the relevant information necessarily distorted the decision-making process within a standard setting body. So I draw your attention to that because it helps to cast light on the general principle and how the competition law is meant to work in this context. It is not reliant.
Was this referred to the CAT?
Sorry.
Was
I'm
this
sorry.
referred to the tribunal?
This was not referred to, I don't think, was it referred to? It wasn't, no. It was not. Final 2 points, if I may, and then I conclude. The fifth point is the sewerage company argument that there isn't a freestanding case of misleading the Environment Agency. This was Mr. Hoskin's respondent's notice. And just to introduce this, you'll have noticed that the overall shape of the respondent's submissions yesterday was that very little was actually said in support of the tribunal's decision that the exclusion provision in section 18.8 is engaged at the stage of causation and loss. The major focus was on the issue of whether it comes in at the abuse stage or breach of duty under competition law, which I've sought to deal with in my first point. And then the remaining focus of my friend's submissions was his points on misleading the Environment Agency, grounds 2 to 4 of the respondent's notice. And here, to emphasise, it is an important dimension of the claim. The claim is explicit and detailed that the respondents relevantly misled the agency for the purpose of the abuse claim, not just Ofwat. And I listed the main relevant paragraphs in opening. Mr. Hoskins said that this does not matter here because the price control is carried out by Ofwat. Transcript, page 172. It is, but the way it works is that the agency is the entity directly misled by being supplied with false underreporting on sewage spills. Ofwat then critically relies on the agency for the information on sewage spills, and it is this that then produces the consequences of the price control, which are the problem.
Can I just understand this a bit better factually? Because I had been under the impression that the information is also provided directly to Ofwat, and indeed that Ofwat cross-checks.
Yes, that's right. Yeah, no, you're right. You're right. That is true. The information is supplied to the agency. The agency looks at it in the round and then supplies a pack to Ofwat. And you're absolutely right in your understanding that also the companies provide information to Ofwat directly, which ought to be consistent with what has been supplied to the Environment Agency. Then, in its enforcement, as you've seen from one of the paragraphs I referred to in Ofwat's submissions, they say that if there's an issue of underreporting, the relevant question is whether the agency is prepared to recognise that this has taken place.
But in a way, that's not where your case is, because your essential complaint is that Ofwat hasn't done anything about this underreporting. So yes. I'm not sure where that point gets.
No, that's just for information to complete the picture on how this happens. Your ladyship is absolutely right again. What I'm seeking, therefore, to point out in this connection is that the supply of misleading information to the Environment Agency is a very important causal factor leading to the consequences about which we complain. And my short point in response to Mr. Hoskins' answer to you is that that is the way it works, and there is no reliance in this, because Ofwat is responsible for the price control ultimately, as was said, on contravention of the Water Industry Act within this allegation of misleading the Environment Agency. The claim in respect of the breach of duty through misleading the Environment Agency only involves the need to look at the operation of the price control regime and to see how information on pollution incidents from the agency feeds into that and causes the enhanced ability of the sewerage companies to impose excessive charges on householders. So I say no more about it, and I come to the final point, with apologies for taking up time. The sixth and last point is the relevance of whether Ofwat has the power to direct the sewerage companies to compensate customers for past overcharges which are imposed on them in a case of underreporting such as this. That was canvassed towards the end of the hearing yesterday, and it is also the subject of Ofwat submissions, and indeed their note provided last night. My submission, it is relevant that Ofwat does not have the power to compensate customers in the circumstances of this claim who have been overcharged. If you go, please, to Ofwat's first statement of position on this, made to the tribunal in July 2024, to look at what they first said, supplemental bundle, page 236, tab 6, and it's paragraph 27.
So, page again?
Page 236, supplemental. Ofwat described its own position in these words. 27. As acknowledged by the parties, Ofwat cannot compel companies to provide redress to their customers with respect to any breaches identified in its investigations, but it may accept undertakings to provide such redress in lieu of all or part of the financial penalty. Now, this deficit that was identified there, that Ofwat doesn't give compensation in the case of overcharge on the same basis as our claim, it is important because it means that if the sewerage companies are right, that when properly interpreted, Section 18.8 applies, and it bars the case, bars the claim. It excludes a well-arguable claim in which millions of householders can vindicate their legal rights through the collective regime to recover compensation which is due to them, and where there is no real prospect of compensation through Ofwat. That was the point that exercised the tribunal in its judgment below in paragraph 51. If the court recalls, it says at paragraph 51, well, we've concluded there's exclusion. Perhaps we should just go back to that to have it fresh in our minds. Core 10, paragraph 51. They say, we reached this conclusion on what we consider as the clear application of Section 18.8, as explained in Manchester Ship Canal. Nonetheless, we would feel concerned if this meant residential customers overcharged for their water supply would be left without any prospect of compensation or reimbursement. However, Ofwat told the tribunal in the course of the hearing that it considers it has power through the enforcement order pursuant to Section 18 to direct a company in breach of condition to reimburse customers the amount of the overcharge. Footnote, this is contrary to the position set out by Ofwat in the statement that we've just seen. In response, Mr. Hoskins stated the defendants accept Ofwat has that power. So that is what I'm focusing on now. It is relevant.
What's it relevant to? Because it can't be relevant to construction of the section, can it? If this is a question of construction of Section 18.8, how it works in one particular case can't be relevant to the construction of the section, can it?
Well, how it works in one particular case can't be relevant. It, however, comes back to the point that my lord you raised in relation to paragraph 118 in Manchester Ship Canal, which is whether, in this case, if they are right, then this section is being interpreted in the way that the Supreme Court was directly concerned to avoid. It would be meaning, in this case, as in any other case where there's a breach of private rights, a tort, it would be taking away a right to compensation on behalf of private parties.
Well, if the statute does it, it does it.
Yes. What was said in response to my Lord Justice Zacaroli yesterday was, but we've already got the answer to that. The Supreme Court has taken it into account and said you need to have the essential ingredient being the contravention of the conditions of appointment.
So this doesn't take us beyond that, does
well, except that the argument before your lordships today, and ladyship today, is precisely what is meant by the Supreme Court, and does it cover the situation that we're concerned with here? And to answer that question, my proposition is that it's relevant to recall that the Supreme Court, in understanding the extent of that exclusion, was concerned that it should not mean, it should never mean, taking away pre-existing private rights. In other words, the situation where the italicised words at the end of Section 18.8 apply, and it should only apply in a case where what is being relied on by a claimant is contravention of the conditions of appointment as the basis for a legal claim. So it's really
That's just the argument, isn't it?
I'm sorry?
That's just rephrasing the argument that we're having to deal with.
It is, but what I mean, therefore, to say, perhaps what I won't do, therefore, is develop this extensively at all. But what I wanted to do was first to say that it comes back to the point, the purposive point, that led to the Supreme Court's decision as they articulated it. Because we do have here, in my submission, a situation where you cannot say, well, this can all be dealt with by Ofwat, and these class members can get their compensation through a regulatory system. That was the point that the tribunal made it took comfort from in paragraph 51. It's not correct, first. And secondly, it comes back to the question that essential ingredient means, as I say, something that does not deprive you of rights, where the regulatory system does not offer an alternative form of compensation. The only point that I will make finally is this. If the question is, does the regulatory system here allow compensation for the householders in relation to the matters pleaded in the claim form, then that has not been answered, and it has not even been answered in Ofwat's most recent document yesterday. You'll recall that I took you an opening to our letter to Ofwat at the end of last year, where we specifically said for many of these breaches, they're in the past, price review period 14, PR 14 in particular, they've had their effects. There can't be any question of ongoing or future breaches in relation to these, can there? And the answer that came back was, this is hypothetical, we're not going to address it. In an appropriate case, it may be that underreporting in 1 year or a problem in 1 year, contravention, might have knock-on effects in a later year or price control period. But they didn't address the particular case or answer that question. And all I say very briefly about their submission last night is you'll notice a change in it again from their 22nd of December letter. You'll notice that it no longer refers to in an appropriate case and gives, without perhaps meaning to, a different impression that perhaps they would be able to deal with all of the problems that are covered by the claim form in this case. That, if that is what is suggested, is not correct and cannot be right. So, my Lord, if there are...
Anything else? No. Thank you very much, Mr. Tanner. Mr. Hoskins, you certainly have a right to speak about Rambus.
Rambus, that's why I rise.
And if you wanted to answer the question I put to Mr. Tanner in very short order, then if we would be assisted by it.
I'm not sure I can add anything beyond. You've raised the point, Mr. Turner's made the point. I'm not going to speak for the sake of it. So I'd just speak to you about Rambus. Rambus was referred to, or is referred to in the claim form, footnote 118, but only in relation to paragraph 28, not paragraph 39 that you were just shown. And I'm sorry, this is a jury point, but if Rambus was the answer, you'd expect it to be referred to before now. The first time it's been referred to...
There's only 3 of us there.
A small jury, but a powerful jury, if I flatter you. This is the first time this point has been raised orally, and again, I don't make a complaint about that. It's just if this was the answer, we'd have heard about this a long time ago. So what? I'll deal with Rambus. Rambus was a Commission decision, December 2009. It predates AstraZeneca in the General Court, which was, the judgment was July 2010. Rambus is a commitments decision, as you'll see when you do have time to read it. The Commission expressed a provisional view, and then Rambus offered commitments so that the investigation wouldn't go any further. So it is a provisional view of the decision, of the Commission, sorry. And if you actually do look at it, it doesn't help, my learned friend. It's all very well to take a paragraph out of context, but as we have learned in this case, particularly in abuse cases, context is everything. Can I ask you to begin at paragraph 1? This decision is addressed to Rambus, concerns the claim of potentially abusive royalties for the use of certain patents for DRAM chips. The alleged deceptive conduct relates to the non-disclosure of the existence of patents and patent applications which were later claimed to be relevant to the adopted standard. And then if we go through to paragraph 27, you'll see the heading Practices Raising Concerns. In the preliminary assessment, so preliminary assessment before this commitments decision, the Commission considered that Rambus may have engaged in intentional deceptive conduct in the context of the standard setting process by not disclosing the existence of the patents and patent applications which it later claimed were relevant to the adopted standard. Such behaviour is known as patent ambush. Then paragraph 28, which was the paragraph referred to in the claim form, the Commission took the view that Rambus may have been abusing its dominant position by claiming royalties for the use of its patents from JEDEC-compliant DRAM manufacturers at a level which, absent its allegedly intentional deceptive conduct, it would not have been able to charge. In the preliminary assessment, the Commission provisionally concluded that claiming such royalties was incompatible with Article 102 TFEU in light of the specific circumstances of this case. So that's confirmed by AstraZeneca as the appropriate approach, including Rambus's intentional breach of JEDEC policy and the underlying duty of good faith in the context of standard setting, which resulted in a deliberate frustration of the legitimate expectations of the other participants in the standard setting process. So the context involved the JEDEC policy and the underlying duty of good faith, and I'll show you what those two sources mean in terms of the duty or the obligation to report. Then paragraph 30, under the heading Standard Setting Context and Patent Ambushes. In the preliminary assessment, the Commission considered that specific context relating to standard setting was important to properly assess Rambus's conduct. The process of standard setting amounts to collective decision-making where there is a risk of anti-competitive outcome. In essence, standard setting provides a forum where companies come together and agree to exclude certain products or technologies from the market. And then 32, I'll ask you to read it because it's quite long. This is what was referred to in paragraph 28 as the duty of good faith in the context of standard setting.
Yeah.
So in the context of intellectual property law, and in particular in relation to standard setting, there is a legal obligation of good faith. Then the JEDEC policy is at paragraph 35. In order to ensure that any accepted open standard is accessible to the industry, JEDEC's policy was to exercise particular care when considering standards that might require the use of proprietary technology. Standards that require the use of a patent could not be considered by JEDEC unless all of the relevant technical information covered by the patent or pending patent was made known. So that was the specific JEDEC policy. Then 36, to give effect to this policy, all members were required, or at the very least expected, to disclose to JEDEC any and all issued or pending patents of which they were aware, which might be involved in the standard setting work of JEDEC. So there was a general obligation in intellectual property law. There was this specific JEDEC policy of disclosure. 38, the Commission provisionally concluded, so this again is the prior provisional assessment, that the JEDEC patent policy and the underlying duty of good faith intended to provide members with an opportunity to develop open standards free from potential patent claims. In other words, the policy, so the JEDEC policy, was aimed at preventing one member company from secretly capturing the standard by not disclosing to GEDEC that technologies being included were covered by the member's granted patent or pending patent application, etc. And then the paragraph that's now relied on, paragraph 39. It should be noted, however, while the Commission considered that Rambus may have breached GEDEC's patent policy in its preliminary assessment, an actual breach of the precise rules of a standard-setting body would not be a necessary requirement for a finding of abuse in this context. Why not? Because there's the general obligation of good faith in intellectual property law. And then the Commission went on to say the finding of abuse would rather be conditioned by the conduct that has necessarily influenced the standard process in a context where suppression of the relevant information necessarily distorted the decision-making process within a standard-setting body. Now, there are two elements to this which are relevant to the issues before this court. First of all, is that there was an obligation in relation to Rambus to disclose all relevant patents. And that obligation came from the general obligation of good faith in intellectual property law. In our case, the obligation to provide accurate information only comes from the conditions of appointment. And, my lady, as you put it to Mr. Turner, the particular allegation of abuse depends upon the obligation to report accurately in the conditions. To put it another way, the claim could not run but for the existence of those conditions. And
I'm not sure whether you're trespassing outside Rambus.
I'm so sorry. Well, I'm trying to...
Can I just ask this though?
Of course.
So your point about Rambus is that the reference to it not mattering that it was a breach of the standard setting body rules is irrelevant because it was in the context an abuse of a breach of a duty of good faith.
Yes, and you see that at paragraph 42, for example. I haven't got there.
So is one possible answer in this case that this is, I mean, abuse of dominance is there's no fixed categories, and this case also includes abuse of dominance in all the circumstances, not just through this supposed category of misleading a regulator. Is one possibility that the conduct here at the end of a trial might be found to have been abusive purely because of the failure to give information, so without relying upon that also constituting a breach of a condition? But one other possibility is that the fact that it was a breach of the condition will be found to have been critical to the finding of abuse. Rather like, well, no, leave it there.
Well, my submission is you can and should decide this now. This is an application for certification of a particular claim. It's not the way the certification process works isn't here's a suggestion of what a claim might look like, and there may be other possibilities. There is an obligation on a proposed class representative to come to the tribunal with a full claim of what they intend to run. And it's on that basis that the certification conditions are then considered.
So,
you can't come at large.
So thinking, the answer to my question is, if it turns out to be an essential requirement, the claim fails.
Absolutely, it would fail at the if it had been certified and we got to trial and we'd won on Section 18.8. Absolutely, the claim would fail in any event. And we're here now because we don't need to spend millions of pounds having a trial. And the second point from Rambus, from paragraph 39, is it's the final sentence. It's that the context is suppression of relevant information. And you have my submission on that. Relevant information in Rambus was withholding patents relevant to the standard as it had been set. And here, the allegation is the relevant information is withholding the PI information as defined and as required to be provided pursuant to the conditions, which is relevant to Ofwat's price control regime. And I won't trespass any further, my lord. That's
Thank you
what I wanted to say on Rambus.
Well, very good. Well, thank you all very much for that argument.
I'm so sorry to
Oh,
rise
sorry.
this unwelcome moment. If the court considers that the Section 18 question may be relevant to its determination, then perhaps I could make a few brief responsive observations to
Mr. Turner's
submissions.
Well, it seems to me that your submissions that he took us to give the answer to that.
My lord, those were the submissions at the outset. That was our first statement in response to regulatory regime.
Right.
Subsequently to that, there are a number of places where we've sought to clarify. We've clearly not done a very good job of it, but we've sought a number of times to clarify, including orally in front of the tribunal, our position on this. And if it will assist, I can try again.
Yes, try again.
Well, first of all, as to the particular case, my friend is entirely right. What we say is hypothetical, is theoretical. Ofwat has not sought to make Section 18 orders in respect of these matters in issue here, and I don't suggest that they are imminently about to do so. The point we have addressed is at the level of theory and principle, and that is because we have not wanted the tribunal or this court to proceed on the basis that Ofwat accepts that, in the event it were to discover historical underreporting resulting in historical overcharging, that it would not have power to do something to put that money back in the pockets of bill payers. Now, we don't suggest there's such a power under Section 23, which is the power to impose financial penalties. 22, I'm corrected. That is a power that arises in relation to past or ongoing breaches, and Ofwat can accept undertakings using that power, but penalties paid go to the consolidated fund. All of that is common ground. So we're concerned with Section 18, which is a power, indeed a duty, to make enforcement orders where an operator is contravening or is likely to contravene a condition of appointment. So again, common ground that concerns ongoing or likely future breaches. So the question that my learned friend has raised and explored with Ofwat is, in a case in which it was discovered that there had been historic underreporting and that had affected the revenue allowance in a past year, so there had been historic overcharging in relation to that past year, and it was subsequently discovered, would there in principle be anything Ofwat could do to return the money to consumers, or is it limited to imposing a financial penalty or accepting undertakings if they're available? We say that it is not so limited. That is our position. My friend is also right that this is untested.
So what is not so limited?
Ofwat's power in respect of reimbursement of consumers is not limited to its ability to impose a financial penalty and accept undertakings in lieu of such a penalty. So Section 18 imposes a duty to make an enforcement order in respect of a continuing or a likely future breach of a condition. The relevant condition in this case is B 9.1, which requires operators to levy charges in a manner best calculated to comply with price control. Now, the price control for PR 14 and PR 19, as we know, included provisions that permitted operators to earn rewards or incur penalties in relation to performance against targets, including the pollution incident target. Now, suppose that an operator discovers that they have underreported their pollution incidents and overcharged consumers as a result in the past. The question is, what does the requirement to levy charges in a manner best calculated to comply with the price control require of that operator going forwards. Now, Ofwat's position is that what is required by that obligation going forwards would be to make an adjustment. Stands to reason. The obligation is a standing obligation to levy charges in a manner best calculated to comply with the price control. If there has been historic overcharging which is discovered, that obligation requires operators to make an adjustment going forwards. Ofwat's position is that that is an obligation it could, in principle, in an appropriate case, enforce under Section 18. Now, it has never needed to use that power for that purpose. What happens as a matter of fact, where past overcharging is discovered, is that the companies agree to make such an adjustment. That is what happens. And again, that stands to reason. And that obviously isn't a case of Ofwat making an enforcement order to achieve that effect. But it does, in my submission, suggest a shared understanding that that is what is entailed by the obligation to levy charges in a manner best calculated to comply with the price control. So, my Lord, I'm not here to defend that position, I'm here to elucidate it, because Ofwat has never made such an order, but that, if it helps at all, on top of everything else, is the logical basis of our position. The one other thing I would say on this point is that we would, to the extent that the court considers it relevant, we would discourage the court from making a finding as to whether Ofwat has that power in principle in the context of these proceedings, when, as I say, it remains hypothetical. Ofwat has never made such an order, and it is not what is being litigated in this case. And so it would, in my respectful submission...
You'd like it to remain possible. Can I ask you a question, please?
Yes.
I'm looking at paragraph 51 of the
Yes.
tribunal's decision, and I'd like you to tell me whether the sentence that reads, however, Ofwat told the tribunal in the course of the hearing that it considers that it has power through an enforcement order pursuant to section 18.1 to direct an undertaking in breach of condition to reimburse customers the amount of the overcharge remains accurate.
It remains a correct statement of Ofwat's position.
Thank you very much. Any points either of you would like to make?
Only very briefly, that the key question here, as I adumbrated, is whether losses sustained through the overcharging and underreporting back in the early price control period, which is the subject of this claim, 2015-2020 in particular, that would, in Miss Boyd's words, be an appropriate case. The reasons that I've already explained yesterday, we don't see how that can be. On her logic, paragraph 9.1 can apply only where underreporting in 1 year affects, through the system, the prices that can be charged later. If it doesn't, then there is no possibility of this being used. Perhaps if I can just show you one illustration of this, and then I'll stop. In the supplemental bundle, if you go to that, and turn to page 123, you see it pictorially in one page. This is the expert report on the claimant's side, and he shows you, if you have that open, it's figure A4.2. This is relating to how things work for Severn Trent, and you'll see a list of years on the left-hand side. So take 2015, 2016, the first year, and there's an arrow which shows the price control year that then affects for the purpose of charging. And for the whole of the claim, apart from at the very bottom, you'll see that underreporting in those years has its effects in those periods, which are now past. And the point that we're making is, yes, in principle, we understand that it's possible in their system that underreporting in 1 year might have effects which are still ongoing or future, or affect future years for the purpose of Section 18. But that is not this case very largely. And that is the point we've sought to put to Ofwat and which is relevant to this court's consideration.
Good. Well, we will take time to consider our judgments and we'll hand them down. I have in mind that the decision may be price sensitive, and in those circumstances we will only give you a very limited time to make typographical corrections to the judgment, probably less than 24 hours. We will give you notice, however, that it's coming before you get it, so that you can deal with it. We'll then give you a further period, perhaps a week or something, to agree the order and costs and make any written submissions about those matters. If you can't agree them, it is extremely important, for the reasons I've given, that the embargo judgment is very closely controlled and only in the hands of named persons and is not leaked, as of course you all know. But thank you very much for your submissions. It's an undoubtedly interesting and important case, and we will carefully consider your arguments. Thank you.
Court rise in favour.